Hey everyone, welcome back. It's the last week of this extra content going on at C2 tables. How's everyone doing? Pretty good? Surviving law school? That's good. I've got one more person. All right. So what we are doing today is we're covering defenses. All right. So for the past 10 weeks, okay. So for the past 10 weeks, we've been doing various content. We started off with the fundamentals of criminal law introduction, sentencing framework, elements of a crime. Up to then, that's when sort of your quiz was. And then we look at offenses against the person. We look at sexual offenses. We look at homicide. And finally, we look at the different types of defenses. Next week, we're going to do a revision. All right, next week's revision, I think it's been posted on LSS website, but I'm not yet making an announcement officially, but I believe, just check the Facebook group again, double confirm, but I believe it's next Friday. Let me try that down here. I believe it's next Friday. 7 to 8:30 p.m. Okay. Probably in person. I haven't booked a room yet, but I will let you guys know an update on that. I will send a full exam paper after today's lesson. We're going to look at that full paper after today's lesson, and then you can attend them. Time yourself 2.5 hours, do that paper, and then we'll go through in that session. Okay. Any questions regarding the revision seminar next week? No? Okay. Also, what you guys should be doing is you probably get some past exam papers from that just in time. Now, you're going to probably get some past exam papers from the past few weeks as well from your chief examiners. I would recommend that you guys do that as well. It will be very, very good for your revision. All right. So that being said, let's look at the lesson outline for today. So we're still breaking it down into content and practice questions. So the main thing for today, there are sort of the three main things I'm going to cover today is self-defense, intoxication, and necessity. Okay. Under self-defense wise, there is this family violence provision that we're also going to look at as well. That falls under self-defense. Okay, family violence provision is not one of these defenses by itself, but where it is involved, then you'll discuss it under self-defense. Okay, and then we'll do problem question 5, which is a continuation of questions 3 and 4 of the LSS booklet. All right, so let's go to self-defense. Before that, actually, overview of the legislation for defenses. Okay, so I suggest you should print out section 322 of the Crimes Act, just like how you printed out, 35 to 45 for sexual offenses, 15 to 24 for offenses against the person. Okay, I'm just going to put this on the board as well in case anyone wants to refer. At least that's what I've did for my exam, and that's what I've been doing sort of for this while for all my other units. So just chuck this here. So section 15 to 24 for offenses against the person. Section 35 to 45 for sexual offense. Section 322 for defenses. One other thing you could consider is section 3 to 9. Not most necessary, but for homicide offenses, you could look at the law, but this 3 to 9 didn't really find it that helpful when it comes to my exam criminal law, because homicide is mainly a common law offense. Okay, so section 322, what happens? You start off with definitions, and then you look at the onus of proof. 322J looks at evidence of family violence. It falls under 322K as well. And then what else do we have? Abolition of self-defense and common law. So please do not bring common law act for self-defense. Okay, I've seen so many past examiners, chief examiners report, they just say that, oh, students do not understand self-defense because they brought in common law authorities for that. And then we look at duress, and then sudden extraordinary emergency, abolition of necessity and common law. So I wouldn't even refer to common law, as in there are obviously some cases for you to study and understand, but yeah, it's purely legislative section over here. All right, so the first thing we're doing is self-defense. This is the relevant sections over here. So you always start off your exam or your answer with this idea, right? We always talk about IREC. So the rule over here, self-defense is under 322K. A person is not guilty of an offense if the person carries out the conduct in self-defense. And there is self-defense if, first of all, the person believes that the conduct is necessary. Okay. And second of all, that the conduct is a reasonable response in the circumstances the person perceives them. So if we see that the top one over here, the person believes that the conduct is necessary, that is a subjective element. Okay. And then the reasonable response in the circumstances, you ask yourself what the objective person would do. Okay. So you want to analyze the different circumstances that the person is involved, and then you make a value judgment for 322B. So that's really the main thing. That's what we talk about. The idea of subjective element, 322A, and then let's look at objective element. Okay, so I just put in some of these relevant factors that you could consider when it comes to the objective element. Okay, so you might the phrasing of the legislation is that it's a reasonable response in the circumstances. So some of the things that you could analyze are the facts within the defendant's knowledge, the relationship between the parties, the prior conduct of the victim, the personal characteristics of the defendant. Oh, by the way, the delusional beliefs and stuff, they were addressed in the legislation as well. So you want to look at this. Obviously, this is not comprehensive. You could look at a lot of other things as well. You could make use of the relevant facts that you think are useful and make a value judgment whether, objectively speaking, it's a reasonable response. Okay, so this is sort of your analysis. Okay, I can tell you the law on the 322K, pretty straightforward, and then you do some analysis. Now, let's move on. When you want to raise self-defense, the legislation, the statute makes it clear that there are only certain situations where you could act in self-defense. So these are some of these situations that the note 2 of section 322K states. A person or defendant may act in self-defense in order to defend themselves, defend another person, okay, prevent or terminate forced imprisonment, protect property. So in the exam question, it's pretty straightforward. Say, for example, you have two persons fighting, one of them, okay, try to stab another person, and then maybe defendant steps back the person. Okay, maybe previously your analysis was around the lines of manslaughter being made out. And then you raise the idea of self-defense. Usually you'll be defending yourself or defending another person. Some of the most common ways I could think of defending another person is the previous question was a sexual offense question. Maybe the two of them are husband, wife, girlfriend, boyfriend, and then they stabbed the girlfriend, the boyfriend defends another person, possibly. Okay, or the protection of property as well. In last week's homicide question, I believe that was along the line of don't come near my property. So that could be one of the cases as well. Now, just bear in mind, when it comes to murder, okay, section 322K, subsection 3 states that the defendant must have believed that the conduct was necessary to defend themselves or another person from the infliction of death or really serious injury. So if I just throw you a simple punch or something light, it's not enough. Okay, if you want to murder, if you are charged with murder, for you to defend yourself or act in self-defense, then you must be, okay, defending yourself from death or really serious injury. Just be very careful of that. So where self-defense is relevant, you need to raise section 322K subsection 3 and make analysis. All right, let's move on. Now let's talk about family violence. And later on in the practice question, we're going to talk about this as well. So a lot of students, they confuse the idea of family violence, the provisions of family violence. So first of all, let's just talk about some of these cases that might be relevant. So if you look at this, sorry, not cases, I want to really specify a lot of legislation actually. 322J, 322M, 322P. Okay, so evidence of family violence will argue one of these defenses. Okay, that's where things coming very relevant over here. Now, so first of all, we want to start off by defining what the family member is. Okay, so section 322J gives you a series of definitions. Okay, it could be a person who has been married, intimate relationship, father, mother, stepfather, stepmother, child, guardian. Okay. And then note violence means, okay, physical abuse, sexual abuse, psychological abuse, intimidation, harassment, damage to property, threats, or physical abuse. That's a series of things that you could look at. So that's when you want to look at the question and then you analyze, okay, whether there was a family member, whether there was a violence, big headings. And then what you do after you define family violence, you need to understand the operation of family violence. I've seen so many past examiners report that just say students do not understand the operation of family violence. What they do is, okay, they put family violence as a defense on itself. Defense 1, self-defense. Defense 2, family violence. Defense 3, that's wrong, right? Because family violence falls under self-defense. So if you look at subsection 2.1, without limiting 322K for the purposes of an offense in the circumstances where self-defense in the context of family violence is issue, person may believe the conduct is necessary in self-defense, reasonable response, even if, okay, the person is responding to a harm that is not immediate. Or the use of force, okay, the response involves the use of force in excess of the force involved in the harm or the threatened harm. So what this means, normally speaking, in your self-defense, okay, if I throw a punch at you for maybe I kill you, let's not say that. Maybe there was a threat that was of a future danger. Okay, let's say in 2 years' time, I'm going to kill you, stab you, and then you will show up and then you stab the person. Oh my God, you're gonna kill me in 2 years. That's scary. Normally, that wouldn't be allowed. That wouldn't be self-defense because it's not a reasonable response. But suppose that the defendant and the victim has a relationship, they are their family members. There was a history of family violence that you've established. Then the operation of this provision will allow you to respond to a harm that is not immediate. That means the victim could have said that I'm going to kill you, stab you in 2 years. Okay, it's not an immediate harm, but because there was the evidence of family violence, that's when things start to become a bit tricky. For example, there was a case, I couldn't exactly remember the name, but it was a husband and wife, and then every single time the husband opens the door or slams the door, okay, he will do something nasty to the wife. He will hurt the wife, for example. And then, or maybe he will physically abuse the wife every single time. There was one night, okay, the husband slapped the door again, and the wife took out a gun and shot at the husband, for example. Okay, the husband haven't done anything yet, but because of this relationship of family violence and all this evidence going on, okay, then that's when this provision come in play. Subsection 2 tells us that without limiting to the evidence that may be adduced, okay, where family violence is an issue, okay, it might be relevant in determining whether or not a person carry out the conduct while believing it to be necessary in self-defense or the conduct is reasonable in the circumstances as a person perceives them to be. So what this means is actually you have subsection 322K, where you're looking at okay the necessary, whether the conduct is necessary, and then you're looking at this is 2A, and then you're looking at 2B. Okay, it's a reasonable response. This is 322K, by the way. So when family violence come in play, what exactly this 322M tells you is that family violence will be both relevant to necessity and reasonable response. So you add in subheading, sub-discussions in 322K if family violence is an issue. Any questions with the operation? No? Okay. Let's move on. Now, the best students will also tell us the operation of jury directions. So these are just some of these checklists that you have to sort of go through them to state the rules before you even do analysis. So the defense of the accused may request any time that the jury direct on family violence in accordance with 59 and 60 of the Jury Directions Act. Okay. And then there are some of these main issues that you could look at. Yeah, so I would suggest you to print out the jury directions as well. 59, 58, 59, 60. For sexual offenses, I believe 46 and 47, that's very relevant. Okay, so you're looking at in giving a direction under 58, trial judge must inform the jury that self-defense is likely to be an issue and evidence of family violence may be relevant. And then family violence could be committed by another person against the accused or a third party. Okay, and then there's a series of directions under 58 to 60 that the defense counsel or the accused may request the trial judge to inform the jury. All right. Now, there is this 322N, abolition of common self-defense and common law. You realize that throughout these past 20 minutes, 25 minutes or so, I've not talked about common law actually. There are obviously common law in your cases. Cases also is one of those cases you learned, right, and everything. But I only have like 40 minutes or 30 minutes to discuss content with you guys. I still want to do practice questions. I just tell you what you need for exams. It's good for your understanding, but yeah, I just don't see how you could use those cases in exams. Okay, so this means that you shouldn't bring in cases for self-defense because of 322A. All right, let's move on. So we're done with self-defense and the subsection of family violence provisions. Now we're going to look at intoxication, duress, sudden, and extraordinary emergency. All right, so first of all, let's look at what this reading guide says over here. So first of all, effect of intoxication or defense, that's under 322T. Intoxication generally, okay, and then Crown and Dudley and Stephens, and then Duress. Oh, by the way, you know, I was doing a lot of reading, just a sidetrack. So I was reading a lot of Dudley and Stephens before you I entered law school, just for some, because I was applying to a lot of interviews around when it's really their cases. Absolutely gross. But yeah, if you guys interested in that, you could read that. So I watched a lot of videos on that back there as well, philosophical stuff. So that was like, I remember, honestly speaking, that was one of the cases that I actually found interesting in the entire criminal law unit. Before that, I was like other units, where, you know. So yeah, and finally speaking, we have duress and sudden extraordinary emergency. So you want to know what are the main common defenses, main headings of defenses. Okay, so this tells you the guide. All right, let's move on. Okay, so if you look at this section over here, it tells us that the big headings of self-defense. Defense includes self-defense, duress, and extraordinary emergency. So these should be your big headings if you raise defenses. So that means if you have intoxication, it will likely going to be a sub-issue. So intoxication means, okay, the influence of alcohol, drug, or any other substance. So where there is a defense, and then you say, okay, is there a reasonable belief? In determining whether or not a reasonable belief existed, regard must be had to the standard of a reasonable person who is not intoxicated at the time. So, for example, what this means is that you have treating 2K, you're raising self-defense. And then once you're discussing 2B, you're talking about reasonable response or reasonable belief. Then you have a defendant who is drunk. Okay, he went to D1 on Friday night, got really drunk, and then did some really crazy stuff. And then he's trying to argue that, oh yeah, because I was drunk, so it's reasonable to believe that maybe the person I met, okay, gave me consent to do whatever offense he committed, for example. Then because his intoxication was self-induced, then you have to have regard to the standard of a reasonable person who is not intoxicated. So that's what subsection 2 or 3 tells you. But okay, subsection 4 tells us is that if the person's intoxication is not self-induced, regard must be had to the standard of a reasonable person intoxicated to the same extent. And then subsection 5 tells you that, okay, when is intoxication self-induced? So notice that subsection 5 tells us there's a presumption intoxication is self-induced unless one of these 3 circumstances come in play. It is involuntary because of fraud, okay, because use of drug prescription. There's a bit more, sorry, actually. You should read the legislation and more a bit, yeah. Sorry, see here? No. Okay, and then you want to go and read. I believe there's a bit more to this. So go and read it and then have that in your notes. And then if intoxication becomes an issue, throw this out, show your knowledge, and then analyze the cases, analyze the situation. All right, let's move on. Just before. Oops. Okay, so now I'm going to talk about sudden extraordinary emergency. So I believe I only got this over here, and then duress I didn't include that after this, but it's okay. You could look at the statute for that. Okay, so now let's look at sudden extraordinary emergency. So 322R tells us that a person is not guilty, okay, if the circumstances of a sudden or extraordinary emergency. So what happens over here? So this section applies if the person reasonably believes that the circumstances of sudden extraordinary emergency exist, and the conduct is the only reasonable way to deal with the emergency, and the conduct is a reasonable response. Okay. So you want to make arguments in relation to, you see that the 3 factors over here. First of all, there must be a sudden extraordinary emergency, and then there must be a belief of it being the only reasonable way. It's in Dudley and Stephens whether eating humans is the only reasonable way to survive. That might be a question. And then whether it is a reasonable response to the emergency. Then you see this term reasonable response, isn't it? So there might be situations where there are intoxication being an issue. You go back to 322T and see whether or not the intoxication is self-induced or not. Okay? Issues? Questions? Nothing? All right. That's pretty much it. That's pretty much content for today. I want to do a practice question because I'm focusing a lot on practice question, especially today, because I don't want to repeat a lot of things you already done in lectures and stuff. So let's do something fresh. Give you guys 10 minutes. Have that big structure. If you could even type it out, the answers. And then we'll discuss this in 10 minutes. And then obviously I will leave some time at the end of this class with any questions throughout the semester, exam techniques, anything you want to ask me, if you could do it. Okay, so I'll give you guys 10 minutes until 2:40. 2:42. For example, you talk about rate in a concept of include group second and say what's that contains three then you say that in terms of defense. And then after that, we have the next one. If you guys people are how break it, it's not maybe much more people say. So you look at the circumstances of isolation, and then you say, you want to be simple. So if you see the circumstances, it's hearing from the start, then what is aware of his appearance, that is most of the people, and then because of that, it's history. Yes. Possibly. The reason for it is also. And then you bring your notes. So the revision session 7 to 30. You come in only 5. Have you heard of how the
you got it on the wall.
It's just so that's like they changed the smooth comments. Yeah. No, it's also so things like Again, 98, I'm stuck in the same. That action is what I said is The last one? Last one? Yeah. That was like him. Yeah. He didn't actually say something serious. Oh, the sexual. Yeah. He was going for it. Oh, I feel it's one of these. Yeah, and he wasn't explicitly said. He's saying my. I don't know.
All right, shall we go through the questions first and then we'll talk about the plan next week?
Yeah.
Okay, so for these questions, for this question over here, part A, who wants to start us off? Anyone? Maybe someone on that table, please. Yeah. Start me off the general structure for this question. Who wants to do it? Yeah.
Okay.
Yeah, part A, yeah.
Yeah, okay, so you raised the issue of whether these would be liable for, we could raise the defense of self-defense.
Yeah, so start with self-defense, okay, and then you quote, what do you do after that?
We could statute,
Yeah,
case of section 3. And this,
no, 2, okay, because there was a murder or like death of human being, so he must be defending himself from death, a very serious injury. And then there are 2 things, okay, whether the belief is necessary, sorry, whether it's necessary and whether it's a reasonable response to circumstances. Okay. So any issues with self-defense in relation to that? Not really. Yeah, question.
You could argue back and forth whether it's reasonable to do that discuss that. So you could make one point that like he's just eating a lunch, so it's not.
It's just eating a lunch here, that's right.
And that one is like a most wanted.
It's most not the criminal, yeah. Okay, so that might be a situation. So go both ways, that's an argument come in play. Very good. That's what distinguishes you from like HD and D as well, actually. And then second one, what we're going to do is we're going to look at the sudden extraordinary, right? Emergency. And then you simply have to argue whether there was a sudden extraordinary emergency, because it's the most wanted criminal, right? And he was holding a knife as well. And then you want to say whether it was the only way to shoot him. Probably not in this case over here, because he was having a lunch, right? But maybe he could just call some other police force. Maybe he could just go out and handcuff him and check his identity and stuff. Maybe he shouldn't just shoot him like that on the spot. Okay, and then whether it's a reasonable response that the person perceives them to be. 5 marks each. Go through each of them. So that's for part A. And then for part B, what we have, assume that the police officer GY. By the way, some of you, because I remember when I did this question last year, some of the students last year asked whether the police officer was an issue over here. It's just you wouldn't want to assume that something that you've not studied, just treat the police officer as a normal person. But if that do come in as contentious in the law exams and stuff, okay, there's no opportunity to clarify, so unfortunately. So just treat it as whatever you know. If you didn't learn anything special about police officer, just treat it as a normal guy. Okay, now let's move on. So assume that police officer GYZ did not shoot Harry. Instead, Harry's sister Cindy saw Harry. Okay, since young Cindy was bullied and threatened by Harry, and she was scared that Harry may stab her, took a knife. What difference would this make? So the first sentence is you say that this will change the difference in analysis in self-defense. Then you bring the operation of 322 and argue how self-defense might play. And then you say that the threat might not be immediate, right? Because there is no threat. There was no immediate threat, right? He was eating lunch and he shot him. Okay. And then it might be more than proportion, right? It might be more than proportion. And then also self-defense changes the operation of whether it's necessary and whether it's a reasonable response. So based on this information, you'll be arguing B. Okay, and that's the difference. As long as you go in the right path, you'll be this is the easiest 5 marks you can ever get. Okay. So that's pretty much all the main substantive ideas. Okay, it was a really pleasurable journey teaching you guys over the past 11 weeks. Okay, I've seen familiar faces every single week. That's really good. So next week we're going to run a revision seminar. It might be big, it might not be big. I have no idea. Last year I had 60 students coming over. Okay, when normal class size was like 10 students. So my plan is that I'm going to run you guys through the 2021 exam papers from semester 2. I've asked both tables. Most of you prefer it to be time conditions. So far, I could only book in 7 to 8:30 p.m. So I can only confirm 7 to 8:30 p.m. because that's the official LSS timing for this revision seminar. That's when I go through the questions. Let me just finish this first, I'll give you some time. And then after, so I was thinking we could chart this in as 4:30 to 7 p.m. That's a time condition, and then you guys go on a half-hour break, and then can come back and then go through. That's my proposal. That's what I will speak to the Monash Value Services, and I will try to get that arrangement sorted out. And then I'll go through that. You could, if you want, you could do this beforehand. I'll make the paper available right after this. But if you want to make it like time conditions, you don't look at that paper until 4:30 p.m. You come in, sit down, do your stuff, and then after that, 7 to 8:30. We go through. Okay, question.
Just with the exam, is it written or is it on the?
Online.
Okay.
Yeah. So for if you want to do the mock exam, I suggest you just do in Google Docs. But yeah, but for exam is e-assessment, the one that shall give you. Yeah.
It's the 73.
There's recording for that. Yes, that's right. Yeah, it's recording and live stream.
Is the answer
Answer key. Yeah, so not full answer key. There will be examiners report on that. There's no like answer key as in like students' answers or whatever that. But there's examiner prompts like comprehensive 8 pages, 10 pages, mark breakdown, that kind of things. And I'll tell you how to structure. Not like these kind of things that I go through verbally. There's things for you to actually refer to. Okay. And then finally, I was told, okay, that your exam is 4 questions, 20 marks, 16 marks, 12 marks, 12 marks. So plan your time accordingly. Each mark is about 2.5 minutes. For example, 20 marks, 1/3 of your exam, you should spend 50 minutes on it. That's the kind of thing. So sexual offense question, and say your chief examiner told us the focus is on sexual exam question, and homicide defenses predominantly, except sentencing. That means maybe, I don't know, maybe 12 marks might be offenses against persons, maybe not. Right? Or maybe this could be broken down into a 6 marks plus 6 marks question. Because this all depends on a lot of things. I might adjust the 2021 paper accordingly to just fit into something like this as well. But yeah, that's something I'll look into. If not, there's any questions, you could always see me as well, email me, ask me anything. If not, see you guys next Friday. That's it. Bye bye.